Hey there, Erica Librarian here, Blair Cato's title attorney with another edition of Title Tips Tuesday, in which we discuss common issues that come up in real estate closings and how to address them. So today we're going to talk about commitments, title insurance commitments, and specifically what the difference is between a requirement and an exception on your commitment, and when will you need to get a revised commitment from your title agent or closing attorney. So first things first, a commitment is going to be the document that you're going to get, which would commit to issue a title insurance policy, assuming that all of the requirements are met. Okay, so this is a situation where you've asked us to order title. We've done the title review. We're now going to make a big list of two things. One is going to be the requirements that need to be accomplished in order to issue the title insurance policy. And one is going to be the exceptions. And these are going to be all the things that we are not going to be able to insure. So there's not going to be coverage associated with those items. So when you look at your title insurance commitment, you'll see a Schedule B. So Schedule A is going to be the list of all of the information, the relevant information, the insured under the policy amounts, when it was issued, when it's good through, those kinds of things. Schedule B is where you're going to need to look in order to find these requirements and these exceptions to your policy. Schedule B1 is your requirements. The requirements are going to be everything that has to be accomplished in order to issue the final title policy. These are things that we have an obligation to deal with prior to issuing the policy. This is things like mortgages that are currently of record that need to be satisfied. These are going to be things that need to be accomplished in order to have clear title. Pay off judgment liens, tax liens, obtain clarification as to a name difference between the current seller on our contract and the person who is on title, quitclaim deeds or other corrective deeds that may need to be obtained in order to get clear title. The exceptions are located in Schedule B2. These are going to be all the things that are currently of record that we will not be affording coverage over. Typically, what you'll see in this category is things like your covenants and restrictions for a neighborhood, unpaid taxes not yet due and owing, things like outstanding easements. You see sewer easements, SCE and G easements, things like that. Bodies of water and the riparian rights or the access use rights associated with water. Things like that is what you'll see in the exceptions. And so what that means is that the title insurance company is not accepting any obligation to cover those items which are currently of record, because they assume that you and or your borrower, if they're getting an owner's policy, have notice of these issues. So these are going to be the things you're going to want to look at when you're looking at a commitment, to make sure that there's nothing in this list of exceptions that's going to be an issue for you, your investor, your underwriter, or in the grand scheme of things for your borrower. So typically, the requirements, so Schedule B1, are not necessarily going to change. These are going to be the things that we have to accomplish before we issue that policy. They will all be accomplished before we issue the policy. And so to the extent we do resolve something listed under those requirements, being a mortgage satisfaction, payoff of a tax lien, or in a lot of cases, you'll see the requirements say payoff or satisfaction of this tax lien, or confirmation that it is not against that person listed. So a lot of times we'll see these tax liens for John Smith, and your seller is John Smith, and we run socials and we realize it's not the same John Smith. Well, we mark that as cleared, but we don't necessarily need to issue a new commitment to you, because these are all things that already have to be, they're already required to be resolved as part of issuing that loan commit or the final loan policy. Now, the exceptions, to the extent any of those are not acceptable to you, your underwriter or your investor, or to your borrower on their owner's policy, are things that we can seek to either resolve in order to remove. So if it's something like an encroachment from the neighbor's fence or something like that, we can either seek to get affirmative coverage from the title insurance company, meaning that the title insurance company will come out and say, to the extent there's ever a claim about that issue, we'll cover you, or we'll pay somebody to go away, basically. Or if it's on your borrower's final owner's policy, we can ask the seller to resolve those issues. And if they are in fact resolved to the satisfaction of our office through a clean survey, or the neighbor agrees to move his fence and he does, then we can revise the commitment to remove that exception. So in terms of when would you want to get a revised commitment, the answer is really when you have affirmative coverage or resolution of an exception in Schedule B2, but not necessarily when you have a revision or a clarification associated with a requirement in Schedule B1. So we need a revised commitment for changes to the exception. We don't necessarily need a revised commitment when we've resolved an issue in the requirements. If you have any other questions about commitments, requirements, or exceptions, or your final loan policy and how that works, please don't hesitate to give me a call. My telephone number is 803-881-6904, and my email is Erica, ERICA, @blaircato.com. Thanks, and y'all have a great week.